Good morning, everybody. My name is Michael Cover, and welcome to this exceptional meeting of the Mediators New Breakfast Club. It's my pleasure to welcome Lady Justice Asplin, Sarah to her friends, who is in the Court of Appeal and was also involved in the Judicial ADR committee and various other aspects of the look at ADR and the judiciary and the judicial system, along with Jeffrey Voss. So Sarah has given us 3/4 of an hour. She's going to talk for a bit, and then we'll take questions in the usual way. As we've just announced, this session is being recorded, and we will deal with new people attending for the first time to announce themselves at the end. So it gives me great pleasure to hand over to Sarah. Sarah, over to you.
Thank you very much indeed. That's a very kind introduction, and it's a lovely opportunity to speak to you all. Thank you for your time, and thank you, as I say, for inviting me. I'm pleased to speak to such an august body, and I admire the work you do and the service that you offer, which is invaluable and far more difficult, I think, to deliver than some lawyers may wish to acknowledge. And I hope you've all got your croissant at the ready. I can't see any, but I certainly have a cup of coffee. So here we go. You may know, and you've just been informed that I was appointed last year as the lead judge on all things ADR. That's the way I like to spin it. And that I'm also chair of the Civil Justice Council ADR Liaison Committee. As you know, we are living in very interesting times, not just politically. And there's enormous interest in mediation and soft skill settlement, if I can put it that way, and how that can be fitted in to dispute resolution in general and the court process in particular. The challenge is to see these elements fitted in to the present processes and skills of the existing system, and to the digital judicial system, justice system, which is beginning to take place apace, in fact. And I'm sure you're aware of that also. I was asked to tell you about the work of the ADR Liaison Committee. So I'll begin there and use it as a springboard to tell you a little about what's going on. The ADR committee, the CJC committee, has a very wide membership, and maybe there are members who are on this call. And that enables the CJC and the judiciary to be able to tap in to the enormous bank of knowledge and experience of the mediation community, and also those judges in the tribunal system who have mediation embedded in their processes, and also people who are involved in ombudsman services. And so it's a very broad church, which is extremely helpful. I found them to be extraordinarily hardworking and committed, and they are a fantastic resource. And really, we use them, and I say that sounds so cynical, but it's true. And I think they are all very happy to be used in that way as a sounding board for many of the thoughts which are coming out of the process of reform at the moment. At the moment, actually, the committee is considering how best to tailor its resources to the present fast-moving climate in relation to mediation and the reform projects within the judicial system and the proposals for change which are being formulated by the MOJ. And in fact, we have a meeting on Friday where representatives of the civil service from the MOJ are coming to talk about the consultation paper, which I think you'll all know about, but I'll refer to it in a minute or two. these exciting times not only include seeking to increase the tools in the judicial toolbox for traditional cases heard in a more traditional way, but also, as you'll know, cover the digitization of the justice system, and that is moving at quite a pace. For example, the online civil money claims scheme, if I can call it that, is in business and has seen a huge increase in the number of claims issued even in the last couple of months. The new Online Procedure Rules Committee will soon have a responsibility for the digital justice system once of course it's created by the forthcoming Judicial Review and Courts Act. And of course now we're uncertain about the timing and procedure in that regard, but it's obviously essential that there is a new rules committee to meet the needs of a fast changing system. So what can we expect in that quarter and generally? There have been a number of drivers to the dispute resolution revolution. The first, of course, is the master of the rolls' enthusiasm, which should never be underestimated, for offering different types of resolution within and out with the judicial system. The second was perhaps the CJC report, which he commissioned and Bill Wood and I, with the help of others, wrote last year. It was about whether it would be lawful to make mediation compulsory. And I think that has been quite a springboard and a catalyst. Those strands of enthusiasm and the report have been taken up by the Ministry of Justice, who have proposals for reform, which, as you know, have gone out to consultation. And I'll speak about those, as I said, a little later. First, in the online space, in pre-action portals, the mediation process in the widest sense will begin with a series of bots, as they're called, which will pop up suggesting resolution in a simple case based on the parties' positions. The simplest of cases might settle very rapidly on that basis. Those bots, it's intended, will appear not just once, but on numerous occasions throughout the online process in different forms that will be more appropriate as things progress. These portals, such as the Whiplash portal and the RTA portal, are directed towards putting together the evidence that is required from the parties so that an offer can be made. That is the direction of travel. And as you'll know, with the online civil money claims portal, the parties are asked to mediate upfront at the beginning. And if they agree, that goes off to the small claims mediation service. And the claim only comes back into the system for directions if that mediation fails. Where claims emerge into the full digital system, it's proposed that there will be further interventions, whether by a case officer or judge along the way, encouraging sensible settlement or further mediation. And the parties will be directed, it's understood, to mediation at various points. And this is in part a reflection of something that you will know very well, but the Canadian system, one of the Canadian systems, has this, and mediation is offered not just at the beginning, but at a series of focal important points or crossroads as the claim progresses. And that's what's intended. So matters will fall out, whether in relation to small claims to the small claims service, but otherwise, when this mesh is enhanced and increased to greater claims, there will be mediation which is suggested, perhaps by completely third-party mediators, at various stages in the process. That's what's intended. In the court system as it stands, I've been encouraging the use of soft skills by district judges and circuit judges, and I've persuaded the Judicial College to include training in those soft skills in their programs. A number of pilot projects have been undertaken and are underway in relation to whether soft skill persuasion, moving on to judicial mediation or mediation by third parties, is effective. And at the moment, in general, the outcomes from those projects and pilots have been interesting and positive. I've also been encouraging the use of early neutral evaluation in the courts, whether by the judge or by an independent lawyer, in order to set the stage for such an initiative. Obviously, the judge must take a much more positive view of case management. And that comes back to training and broadening of the judicial mind. The judge must always have the possibility in his mind or her mind of whether there is an issue which could be resolved, which would break the logjam and set the stage for that consensual resolution of the whole dispute. I think that actually requires quite a revolution in judicial thinking, and that is what I'm also trying to engineer or light the blue touch paper for it, at least. But as we all know too well, we must avoid singling out issues which in the end don't resolve anything but just increase the costs of an action and create delay. So judges need to be very nuanced in this process, but they need to think laterally and creatively. And it seems to me that we do need better training and awareness in order to enhance this area. As the Master of the Rolls put it, judges are not merely there to referee the fight, they're there in the hope that they can break it up. And I think that partly through the fact that it's a much more traditional process, one waits and then determines the final issue, and also because judges are under enormous pressure, and therefore it's, I hesitate to say, easier to let the process roll on. And thirdly, because the mindset and training has not been produced and created in order to enhance a more lateral thought process. This has been an element which has not come to the fore until now, and we've got a lot of ground to make up. As a complete aside, I should mention that, and you'll see from the background that I've got today, for which I apologise, I didn't realise that it was still there when I switched on. The judiciary of England and Wales have recently become one of the founder, or our system at least, has become one of the founder members of the JDRN, which is the Judicial Dispute Resolution Network. The initiative came from Singapore, and where they use mediation very thoroughly throughout their system. And people and systems have signed up around the globe, including Australia and even China. And we had a 2-day, in effect, opening meeting seminar last month, or perhaps 6 weeks ago, where there were opening position papers, which were given by each of the judicial systems about how, at the moment, mediation skills are used within the system. And I found that extremely interesting, especially as one knows, for example, about Canada and other places. But it seems, for example, that the system in Australia builds in sending matters off to be dealt with by an independent arbitrator, whatever, mediator at certain stages in a case, which I found very interesting. I've also just been to a judges and mediators conference in Barcelona, at which there were very interesting presentations about how mediation is being used in Europe, in the courts in France and Germany and Belgium. And interestingly, also in Ukraine, there was a judge from the Ukraine who was very eager to get back to mediating rather than being displaced as she is at the moment. Let's go back. What part does the CJC report play in all of this, in the progress of mediation as a tool in the toolbox? It addressed the question of the legality and desirability of mandatory mediation. In other words, whether parties can or should be required to engage in mediation in the true sense of the word. We concluded that mandatory dispute resolution is compatible with Article 6 of the European Human Rights Convention, and therefore is lawful. As you'll know, in Halsey and Milton Keynes' General NHS Trust, Lord Dyson, who was the Master of the Rolls at the time, said that it seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on their rights of access to the court. And that was said in reliance on an ECHR authority saying that the right of access to a court could be waived, but such a waiver should be subjected to particularly careful review to ensure that the claimant was not subject to constraint. And that's the Dewar and Belgium decision. At paragraphs 58 and 59 of our CJC report, we concluded that any form of ADR which is not disproportionately onerous and does not foreclose the parties' effective access to the court will be compatible with their Article 6 rights. If there's no obligation on the parties to settle and they remain free to choose between settlement and continuing the litigation, then we considered that there was no unacceptable constraint on their right of access to the court. The logic, we think, could be applied also to early neutral evaluation. In the Rosalba case, which I'm sure you also remember, in the Court of Justice of the European Union, importance was attached to the fact that not only should the parties have a free choice as to whether to settle or not, but also that the ADR process should be free and cause no delay to the ultimate resolution. But we thought that what mattered was that any cost or delay was proportionate. And we concluded that more work was necessary about what type of cases and claims and situations were suitable for mandatory ADR, and particularly which would be most effective in the analog and, online world. I like to think of the CJC report as an important catalyst. And you may know also that, I'm sure you do, that the CJC's recent report on small claims has recommended that small claims worth less than £500 should be subject to mandatory mediation. And there are those proposals are being piloted already in various county courts. These reports have affected, it would seem, the thinking at the Ministry of Justice. And as I've already mentioned, and as you will be aware, a consultation has been launched about the use of mediation in the civil justice system, and automatic referral to mediation of small claims, actually up to the value of £10,000, by means of amendment to the CPR, although it's intended, I think, that eventually there would be primary legislation also. It's proposed that a claim would be stayed for 28 days and referred to the Small Claims Mediation Service on a compulsory basis. It's proposed that there would be a series of exemptions from that compulsory referral query, whether that creates its own industry and is wise or not. And therefore, there's a great deal of thought being given to the nature of the exemptions and the effect that they would have. And also, there are questions about the extent of the discretion which a judge ought to have about all aspects of whether mediation must take place, and if it has, what the consequences are if it doesn't settle. So there are also questions about appropriate or inappropriate sanctions. So all of that is, if you like, up for grabs. And of course, from our point of view, what we are concerned about is that actually a system which is workable and is also fair, and but also doesn't create its own log jams, delays, and additional cost should eventually be created. But it's inevitable that the number of small claims mediators who will be required will be enormously increased. Small claims apparently amount to 61% of the diet of the county court. At the moment, only 21% of cases, only in 21% of cases, do parties both decide to avail themselves of the Small Claims Mediation Service. The government hopes to give about 270,000 parties the opportunity for mediation each year, and free up the county court from around 20,000 cases a year. It's quite clear, therefore, that mediation is going to become, one way or another, it seems to me, an integral part of our justice system, whether in the form of mandatory referral or as part of a soft skills package. It's imperative, therefore, it seems to me, that the public have confidence in that mediation process and in mediators, not only to facilitate successful mediations, but so that confidence is maintained in the process, but also in the judicial justice system itself. We're very fortunate in the UK that our mediation community is generally well regarded, and parties to whom mediation is suggested rarely refuse on the basis that they can't find a sufficiently neutral mediator. But it seems to me that in the future, particularly if there is going to be a real expansion of mediation, not just, and I've been talking mostly at the small end of the market, but throughout the market, particularly as mediation is also funneled in to the justice system as it stands, and encouraged as a freestanding part, but of a case as a whole, that the need for mediators is going to grow exponentially. And therefore, also, in order to maintain confidence, it's going to be essential, it seems to me, that the public know what they're getting. I think it probably won't be particularly, or it may be popular amongst mediators, but it seems to me that there has to be some benchmark or standard. And if there isn't, then in effect, that also diminishes the justice system if we are telling people that they must mediate and that this is part of the whole process. There has to be confidence, but there also has to be a proper standard. I'm not suggesting there's not, but people have to be certain of that. Otherwise, it taints the mediation process itself, but the justice system as a whole. So for the success of the process and for the integrity of the justice system, it seems to me that we need some kind of benchmark or standard or kite mark in relation to mediators. It seems to me also that we must enhance public confidence in a non-court-based dispute resolution process, even though it may be that it has been required as part of the judicial process. So we need to educate people about the benefits of mediation. I'm sure you think that I'm just reiterating what you know already, but even and to the extent that it's done at the moment, it's not, in my humble opinion, reaching far enough. We need to do much, much more. We need to educate people, everybody, not just commercial entities, not just SMEs, but everyone about the nature of the mediation process and the benefits that it can have. It's only if people are familiar with that process and what it can offer them, rather than feeling that they are being fobbed off because what they really wanted was the judge to tell them that they were right, that they will accept it and accept it with confidence. If they feel that they are told at the last minute, and that is how they will feel, I think, that they won't have immediate access to that judge, who of course was going to side with them, and they're required to participate in what they feel is a bit of a covert process, there's really likely to be a problem for the individuals and a problem for the system as a whole. At the steep end of the curve, they may be become dissatisfied and disillusioned with the justice system as a whole. And that is something that we can't countenance, because in this country, at least, I like to think that the public have confidence in the system. And of course, it's one of the indicia of a civilized society that one has a justice system that can be relied upon and that people can vindicate their rights. In the middle of the graph, not at the steep end of the curve, less serious but still quite detrimental, people may already have become impossibly entrenched in their views about the only fair outcome to a dispute, and that the only person who can therefore deliver that is the judge. And so that's why I think we need to educate, soften up the thought process. At the flatter end of the curve, they might well try to find an exemption if exemptions are to be provided from mandatory mediation, or any other excuse to avoid the process. And it seems that to me that the danger in that, and that I think is a product of a failure to educate in part, will be an industry all of its own in making applications for exemption, which will lead to more cost, more delay, and will actually be detrimental to people's Article 6 rights as a whole, and of course will be detrimental throughout and in relation to their particular dispute. So all of these, whether one is at the steep end, in the middle of the graph, or at the flatter end of the curve, they all have really serious negative factors, which must, it seems to me, be avoided. And I think that those negative factors would be magnified in relation to a digital justice system, because people would feel further away from gaining what they consider to be the right outcome, unless we can, therefore, retain credibility and public confidence when using mediation as part of the toolbox, and perhaps a mandatory part of the toolbox, then in fact this will fail and we will all lose out. And it won't be just mediation that's lost out, it'd be the whole system, which is I don't want to be too the end is nigh, but maybe very, very serious for justice generally, and therefore for our country generally. So we must retain that confidence and credibility, and it seems to me that we must all seek to increase the profile of mediation and educate the public at every level about what it entails and how it can be advantageous to them, and a useful exercise which may resolve everything, but may in any event be a useful step in the process to the resolution of their dispute. So I think you need to put down your croissant, and we all need to get going on that and discover what is the best way to put out the message. And that's what I've got to say at the moment. So I hope that is okay, and I'm very happy to answer questions.
So thank you so much. That was fantastic. So now, who would like to ask a question? We're in the meeting format, so put up your hand. There's Andrew Miller, who's our next speaker in September. Martin, would you like to? Oh, you have the floor, Andrew.
Yes, Andrew's.
Good morning. Thank you very much, lady. A fantastic talk. I am now having been a barrister 33 years, I'm now a full-time mediator, and I'm lucky and privileged to mediate almost every week. So I'm about to put a tie on and actually have a pre-mediation call shortly. Can I just question on one point that you said? But I think you're absolutely right. That mediators have to speak more about mediation and have to speak outside what I often refer to as being the echo chamber. You only have to go to gallery view here and you will see that the vast majority, if not totality of everyone, are mediators, and everyone is singing from a similar hymn sheet. The word needs to get out there, and it is not out there. There are many people who still will, if you go to them, and even professionals will not necessarily know what exactly mediation is. And that's very much the case I find in in-house counsel. And I'm amazed sitting in mediation where I find myself explaining the process of mediation, etc., that I'm not stopped and said, Andrew, we know all this already, that I'm met with sort of faces, oh, that's very, very interesting. But you use one phrase that I really want to pick up, where you said that the mediation, and in that, I guess, the mediation fraternity are well regarded. And I question whether that is actually the case, because I saw an incredible sort of increase in mediation during COVID in the remote mediation. And I think the mediation fraternity missed its opportunity to move forward at pace during there. And I now see the old habits kicking in, the hesitation from the gatekeepers being almost always the solicitors to actually go to mediation. A mediation I'm doing next week, to give an example, I was nominated as mediator in September last year, and they've just been fighting amongst themselves about mediation, and not in a sense not respecting the process at all. So it's those words, when you said well regarded, I sort of, it made me sit up and think, I'm not too sure about that, and how do we change it? Why am I wrong, and if I'm right, how do we change it?
Andrew, I'm sorry to hear that, but I think that it is all part of this culture shift, and we're in these interesting times. And the culture shift says this is not something peripheral, additional, etc. This is mainstream. This is a tool, one of the tools, a legitimate tool, not a junior tool, not something which is inferior. This is another way of sorting this matter, or a particular part of this matter, and the rest has to go on to a judge. It's all of an equal standing. And I think that you're right in that. I think that it is, in some, respects, considered to be a bit peripheral. And the answer is that it's coming into center stage, and the spotlight is being placed on it. Because if and to the extent, and all those things I was talking about, and the consultation paper, etc., are about really mostly relatively small claims. But the point is, it's a culture shift. It's a shift then to say this is really good. It's good for everybody. You get this sorted, hopefully more quickly, more cheaply, more imaginatively, etc., etc. And therefore, that's also part of the snowball. It's not peripheral. It's not out with. And so I think that perhaps we have to take this big leap of making. And I know you'll say, well, I'm not interested in small claims, etc. But it's part of a culture shift. It's moving towards, this is all one part, and of one thing, and it has to have the same emphasis, the same respect as every other tool in the box. And I think, therefore, actually making it mandatory to start with in small matters, and Topsy will grow, has the effect then of the other side of that coin is we have to have the confidence in it. But until you make it mandatory, you'll never get the full confidence and the full respect. You will always be slightly to the side, in the wings, rather than in the center stage with the spotlight. And so I think that is I think I understand what you're saying, and I think you're probably right about that. Mediators are well regarded in the circles who understand them, but we really have to branch out. And I think that starting with mandatory mediation in smaller matters will, start the snowball, basically.
Thank you, Sarah.
Thank you very much. I think
we've probably got time for perhaps one or perhaps two quick questions. Who's next?
Jackie Lewis.
Jackie Lewis. Jackie, go
ahead. Thank you so much, Lady Asplin. That was really, really interesting. Two things I want to say. First of all, I'm a civil, commercial, workplace and family mediator. I just need to come in here that family mediation is mandatory before issuing proceedings. And let's say it's, I think, probably 3 or 4 years that system's been working, and you can see it works fine. So all the hesitation for the civil branch may not be as anxiety provoking as the judges think it's going to be. It is mandatory in family. I also see children, which is not mandatory, but still I've seen a lot of children in the divorce process. Anyway, you can say something.
So I agree, of course. But certainly MIAMS hasn't worked, I think, as anywhere near as well as people would like it to. I know there is an enormous growth in mediation in relation to children matters, etc. And that all has to be applauded. But yet again, I think we all need structure.
And we need education. I think you're right. I think we all talk about a storyline in EastEnders and the Archers, and let's open it up and put it in the, let everybody understand what mediation actually is, as well as the judge, the solicitors also, and sometimes the local authorities who've been running cases for 30 years around, best interests and so on, court protection work that costs £100,000 and nobody's thought to mediate it because they're all too frightened because they don't really know what it is. So I just wanted to say that, and it was a great talk, and thank you very much.
Thank you.
On the back of Jackie's question, and just
sorry, hang on. No, please don't jump in. Let's thank you, Sarah. Right, okay. Anita, you've got your hand up. Please go ahead. This is almost the last one.
Bolt on really to what Jackie's just said. I'm also a family as well as a commercial mediator. Most people are probably aware about the Ministry of Justice voucher, £500 towards the cost of joint mediation. So my first point is there any merit in not only or not making it mandatory, but offering an enhancement of taking up civil mediation? My second point is that I've sat on the local family justice board of family mediators subcommittee for 10 years. And in all that time, I've been trying to get opportunities to train district judges. We now are headed up by TJ Peters. She's accepted my information for free training. So my question for you, lady, is there adequate training in the lower levels of courts? And if not, what can we as mediators do about it?
Answer no. It's very difficult to achieve, because in the same way as I think lawyers have an inbuilt concern about mediation, or it's not on their radar, I think the same is true of judges. But there is, and as I say, I've been trying to foster a change of heart and a change of attitude. And I come to the conclusion that actually it's not until these things are required that you move the stone. And then there'll be a sudden flurry of, oh my goodness, perhaps we need some training about this. I have been trying. It's quite hard work. But of course, everybody needs more training, because if you're going to make this revolution work, and there is going to be a revolution, then everybody has to have an enhanced knowledge of what's required of them, how they can best achieve the right result for everyone. So yes, I agree.
Well, thank you, everybody. Thank you, Sarah. I think we should draw a line there, because I know you've got lots of other things to do today. So I would like to say on behalf of everybody, thank you so much. That was really enlightening. There was absolutely no fear of you telling us things that we already knew, perhaps one or two things. And I think it's very impressive with what's going on, and we wish you and Geoffrey Voss every success in your endeavours. So thank you so much. And we look forward to keeping in touch. Perhaps you'll come back next year and tell us how you're getting on. So
I've been delighted. Thank you. And thank you for having me. And thank you for your interesting, stimulating questions. And I'd be delighted, as I say, to come back. Thank you again. And I'm sorry that I have to dash.
Okay. Have a wonderful day. Thank you.